Okay, the first piece of free legal advice that I have for you today. Don't die. Unless you have your estate plan in place. Okay? Don't die unless you have your estate plan in place. Now, what is an estate plan? Well, I mean, when you think about an estate plan, what do you think about? Well, some people think about a will. And they think they have that will, that's all they need. They're set and they're fine. What people don't seem to understand or appreciate is that your will is really your punched ticket to the probate court. If you have a will, and that's the only planning that you have done, you've got a problem. Well, let's go on and let's talk about, let's talk about what estate planning is. There you go. Now everybody, most people have a group of people in their lives, whether it's family or whether it's otherwise, that means something to you, right? And at the same time, most of us have acquired stuff, for lack of a better word. And so what we try to do when we do estate planning is to protect the people you care about after you've gone. And to get a little more technical, it's a systematic process for the accumulation, conservation, and distribution of an asset portfolio. And so what we strive to do when we do estate planning is we want to make sure that as much of the property that you have goes to the people that you love. Easy enough, right? However, there are some things that will try and eat away at some of that, such as taxes and the probate court. Well, we want to try and avoid that as much as we possibly can. Now, as we go forward, why do you want to avoid probate? Well, here's the reality. Probate costs. How much does it cost? And understand that the reason that we have probate, the reason we have probate in the probate court is to solve a very simple yet necessary problem. And that problem is, if you're dead, you can't sign your name. And because of that, you cannot necessarily give certain pieces and parcels of property to those that you love. And so what the probate court does, essentially, is it provides that signed name, in essence. And so, understand that for that privilege of having your name signed while you're dead, it may cost anywhere, the average, 7 to 10% of the value of your estate. So that's 7 to 10% that would go out of the hands of those that you love. Well, that's not good. We don't want that, do we? The probate process can be slow, okay? And that part of that depends upon the size of the estate, on how quickly you can get through that process, okay? However, on average, the probate process is 1 to 3 years. And so, does that mean that your family isn't going to receive any of the assets until the end of that period of time? Not necessarily. But frankly, if a breadwinner passes away, any delay is a bad delay. And so, you want to make sure that you can get through that as quickly as you can. I have a case right now that I'm working on 10 years. 10 years in the probate process. Absolutely crazy. It's one that I inherited. When it came to me, it was already 8 years in the process, and we're still trying to close it out. And that happens, and that's absolutely something that you want to avoid. The third thing that you want to avoid is, once you go to the probate court, everything, basically the will then becomes a public record, and therefore your business comes into the public eye. Anyone can come and go to the court, ask for a copy of your will, and can receive it, and go through it, and have access to what your plans are. I don't know about you. I don't like that. My business I'd prefer to keep to myself. And so, with that, if you can avoid the probate process, Wouldn't you agree that that's probably a benefit? All right, so what are the things that hold this up? And what are the things to avoid? Okay? First of all, procrastinating. How many people in here have a will? Impressive. Half the time I do that, I get only a few hands. Just a few hands. Next question. How many of you have reviewed it within the last couple of years? Okay? A lot fewer hands. Things change. And so the first thing is don't procrastinate it. This is it's one of those things that you say, okay, we'll get to it, we'll do it. Well, you never know what's going to happen, and so it makes sense to do it sooner rather than later. Next. There are a lot of people, I can't tell you how many times I've had people come to me with these do-it-yourselves wills that they get through the internet. They get through some program that they've purchased at some store that will remain nameless, and they then take that program, and with that program, they then receive a will that's 1 page, 2 page, 3 pages long, and they think, oh great, we're set, we're done. Please, please, please don't do that. Every time I've seen one of those things, I've seen a problem with it. And understand what they're doing. The laws in each state differ for what it takes in order to execute a valid will within that state. And so what the program has to do is it has to make sure that it complies with all 50 states. And oh, by the way, did I mention the law tends to change from time to time? And so because of that, that program doesn't always keep up. The other thing is that the program probably isn't tailor-made to your family and your personal situation. And so the information that you may have on there will be very general in nature and not allow you to do things as specifically as you could do. Now, your will. We talked about the will, and most people in here have a will. As I said before, your will is your ticket to the probate court. It makes sense to try and avoid the probate court if you can. Let's talk about some of the other things that people do in their planning. Some people feel that if they have their property and if they're married and they just put it in joint names, or they do that with a child, an adult child, if they've just put their property in joint names, they're done. They're protected, and that's all that you need to do. Well, the fact of the matter is that's not entirely the case, because if that's all the planning that you have done, the problem with joint tenancy is it creates a loss of control with regards to the property and what happens to the property. There's the potential for an increase in liability. There's also the potential of an unintentional disinheritance that comes with that property. For example, let's say that you and your spouse, significant other, have decided to buy a home together. Well, you have this home and you have children together. And so the idea is you have it in joint names so that if one of you dies, then the other will have the property and be able to take care of the children in it. Well, and the hope is that the property will then go down to your children. Well, what happens when you die and your spouse remarries and that spouse has children with the other spouse, and all of a sudden the new spouse's name is put on the property, and all of a sudden your children receive nothing? Well, if you have a joint tenancy plan and that's all you have, then there's the potential for some problems with that. Also, there's also with just a joint tenancy plan, there's the potential of increased taxation for your survivors. And that includes the potential of gift tax, of estate tax, as well as income tax. All right, well, let's go on. There's also the ability in Missouri, not all states have this, but Missouri does. There's the potential to do transfer on death designations. With real estate in Missouri, we call that a beneficiary deed. And that's a great thing as well. There's also the ability with, say, with motor vehicles, as well as with bank accounts, to do TOD or POD designations, with transfer on death, payment on death designations. And so those are examples of those things. And again, these are good. Having this type of a transfer on death policy with regards to your property is good. It's a little better than joint tenancy, but there are still inherent problems with that. And they include, one, there's a very limited control over the distribution that you do, and also it's incredibly inflexible, and it can also result in unintentional disinheritance. And understand that probate will occur if whoever is to receive the property is underage or otherwise lacks capacity. And so you're right back in the probate court, which is what we want to avoid. Now, something else that you probably want to avoid, okay? What you want to avoid is you want to avoid paying taxes. And understand, we're doing pretty good right now. The law that's in place at this time is that there are no estate taxes if the value of your estate is under $5.12 million. I'm in there, so I'm good. Yeah. Here's the problem, okay? The problem is that the law that's in place right now is set to sunset at the end of this year. And if Congress doesn't act upon it, then it's going to go back down to $1 million threshold. And when we talk about that $1 million threshold, we're talking about everything that you have at the time that you die. You're never as rich as you are as the time that you die. And so that would include not only all of your property, it would include retirement accounts, it would include insurance. And so if all of that is over that threshold, then you've got a taxable estate. And so there are things that we strive to do to try to avoid that. And incidentally, the other thing to bear in mind is when that estate is taxed, the amount that's over the $5.12 million, it's taxed at this point, it's 35%. Once it goes back down to that $1 million threshold, if it goes back down to that $1 million threshold, then you're looking at anywhere up to 55%. And I don't know about you, that's not good. Okay. So let's talk about the things that you ought to consider having in an estate plan to protect your family. And I'll add to it that this is what I've done for my family. The first thing that I want to talk about is a revocable living trust. Now, trust is different from a will. Okay, with a trust, it's a document that you draft now. You are the settlor or the grantor of the trust, which means that you're the one that's creating it. You're the one that's setting the ground rules and giving the instructions within that trust. Okay, we name you and your spouse, as the initial trustee of the trust. And so that means that any property that's held within the trust is still your property. And you can do with it whatever you want. And so you control what happens to it. And then we name you and your spouse, as the initial beneficiary of that trust. And because of that, you can really, you can buy, you can sell, you can lease, you can burn, you can really do anything that you want with that property during the course of your lifetime. But the thing to remember about a trust is that the trust survives you. And because the trust survives you, it's already in place at the time that you pass. And because of that, as long as the property that you have is in the trust, you could potentially avoid the probate court entirely with a trust. So the hallmark then of the estate plan becomes that revocable living trust. Okay? And so along with that, you'll have, not only do you name yourself as the initial trustee, you name whoever you trust most implicitly as a successor trustee to make sure that the terms of that trust is carried out for the benefit of your loved ones. Okay, next. Now, does that mean we don't need a will? Answer. Answer is yes. You still need a will. But we use the will as a safety net. And this is called a pour-over will. And the reason we call it a pour-over will is that typically there will only be one distribution paragraph within that will. And what it will say is any property left outside of my revocable living trust, I hereby designate that it be taken and poured over into my trust. And therefore, the trust remains the controlling document. Now, also, if you have minor children, you need to have a guardianship designation within that pour-over will. Granted, with minor children, because if you're striving to have a guardian appointed, that has to go through the probate court. But if your property is not going through the court, it's going to cost a whole heck of a lot less in order to do that. Okay? So, we have a revocable living trust, a pour-over will. Next is a healthcare power of attorney, along with what we call a living will or a medical care directive. Now, a healthcare power of attorney, that's the document that you give someone else the ability to make healthcare-related decisions before you in the event that you are unable to communicate your wishes yourself. Okay? That's beneficial. Along with that is a medical care directive or a living will, and that's the document in which you state if you're ever in a situation where the doctor says that there isn't any hope, there's some incurable disease, you're in a coma, you're being kept alive on the machines in a vegetative state, and there just isn't any chance of recovery or quality of life, this is the document in which you put forth those things that you would wish to have withheld or withdrawn in that event. The reason for that is, well, hospitals cost. And if there isn't any chance of recovery, do you want your estate to be eaten up by the medical bills instead of going to your loved ones? And this is something that has really come into the forefront within the last few years. And it's a document that I think really kind of hit prime time back in the 90s. There was a case out of the Kansas City area involving a young lady by the name of Nancy Cruzan. And Nancy was a young woman, and she was involved in a one motor vehicle accident in which she was found face down in a drainage ditch and was taken to a state hospital. And at the state hospital, she was in a persistent vegetative state. And after quite some time, the family finally made the tough decision to pull the plugs. And the hospital came back and said, we refuse. And they said that they're in the business of sustaining life, not taking life, and therefore they refused to do it. And it's a case that went all the way up to the Supreme Court before a decision was rendered. And at the end of the day, the state of the law is that you have to have clear and convincing evidence of a person's wishes and desires if something like that were to occur. And if you have that, then the hospital needs to listen to it. And so, that's why we have a medical care directive, because that constitutes clear and convincing evidence of a person's wishes and desires. Durable power of attorney. A durable power of attorney is a document in which you give someone that you trust implicitly the ability to handle your financial affairs in the event that you're unable to do so yourself. A number of years ago, a friend of our family's, she was a single mom, 4 kids. She was out on a date, driving down Grand Avenue, and was in a horrific automobile accident. And she was taken to Barnes, and she was in a coma. A couple of weeks after that, I get a phone call from her sister. Her sister says, Kevin, the landlord is threatening to kick them out if the rent isn't paid. I don't have enough money to pay the rent, and I need to be able to access my sister's accounts in order to make sure when she comes out of this that she has a place to come home to and that there's a place for her children to be while she's still in the hospital. My question to her was, well, does she have a power of attorney? Answer, no. In a situation like that, there's only one other alternative, and that alternative is to go to the court, ask for an emergency hearing that the individual be declared incompetent, and then move forward. Well, they didn't want to do that. And so there she laid in the hospital. Fortunately, she came out of that coma about a week later. And as soon as she did, I got another phone call from the sister. I went immediately down to Barnes Hospital with the document in hand, sat down, went over it with her sister, and she signed it right there in the hospital, giving her sister the authority to handle her financial needs for the benefit of her family while she continued to recover in the hospital. She was able to keep her home, children were able to stay, and because of that document, they were able to handle this family crisis that not only affected she and her family, but the extended family and loved ones as well. Okay, so these are what I would suggest to you, very respectfully, would constitute a sound estate plan. Now, there are certainly other things, I don't want to use the word product, I don't think that's the proper word, but other documents that can be drafted based upon the type of property that you have and the amount of property that you have. But I would respectfully suggest that this is the start. All right, so if you have a living trust and any type of estate plan that you have, it becomes vital that it's reviewed frequently. I strive to send out a letter to each of my estate planning clients at least annually, in which I ask them, have there been any changes? Have there been any life events, any deaths, any births, divorces, anything along those lines, any illnesses that would potentially impact that estate plan? And then we talk about any updates that need to be made. Let me mention one other thing, one other benefit that you get with a revocable living trust that you don't necessarily get with just a will. Because that trust comes into play and is in effect once it's executed, because of that, you can make plans for any loved one that you have that may be under a disability. You can make plans for disability in the event that you're disabled at some point in the future. And that trust can help provide for you and for your family in the event of disability. A will can't do that. A will doesn't come into play until you die. And that will is then taken and filed with the probate court. But a trust, on the other hand, fulfills that potential gap as well. So, what do we try to do when we have an estate plan? Well, we try to protect our loved ones. I mean, that's job one. But we want to do it in a way so that we avoid probate and we avoid tax. I thank you for your time and for listening. I've enjoyed the opportunity to do this. I've given, you'll notice, one of the things that I'm trying to do is we always try to do a little better when we do our presentations. And so I have a speaker evaluation form. If you wouldn't mind taking that for me and filling it out. And if you have any comments, don't be afraid to write it on the back. Whether they're nice or not so nice, that's okay too. Anything to make it help me do it better, I would appreciate that very much. Also, one of the things that I'm offering to this group, anyone that would like their estate plan that they have now reviewed or would simply like to talk about their wishes and desires for an estate plan, I'm offering a 30-minute free consultation for that, to to go over and review the documents that you have or talk about what documents you may want to consider. Thank you very much.